first, we'd like everyone to please stand for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Be seated. And I would ask everyone for a moment of silence for our recently departed residents, friends, and neighbors, as well as all of those people suffering around the world. A moment of silence, please. Thank you. Roll call of board members.
Mike Messina,
Present.
Ed Whitman,
Present.
Mary Adler, Matthew Pellicano,
Excused absence.
Annette Bailey.
Okay. Okay, we will now record the approval of minutes from our last open board meeting dated 9/18/25. May I please have a motion from a board member for the approval of the 9/18/25 open board meeting minutes? May I please have a second? Second. All those board members in favor of approving the minutes from 9/18, please state aye. Any opposed, state nay. The ayes have it. The minutes have been approved for the 9/18 meeting. Okay. So today's meeting is a little different. So it's different in one way. We're going to have a little different logistics of how the meeting is run. Before the usual report outs from the various directors, we will have a report out from our attorney, David Merritt, in regard to the lawsuit filed against the HOA and the 5 board members that were, it's actually the last board, which included Charlie Rott and Carol Butterworth. After David's presentation, we will conduct a recorded question and answer period so that any member of the HOA can pose questions directly to our attorney. David, you now have the floor.
Thank you all for being here today. I'm glad to be here with you. My name is David Merritt. I'm an attorney with Montgomery Legal Services. We are the law firm representing your homeowners association. So we represent the association as a whole. We don't represent management. We don't represent contractors, developers, or builders. Our firm is about 10 attorneys, and we represent associations across the state, and that's all we do, is representing homeowners associations, condos, and co-ops. I'm sure you may have seen Mike Palulak from our firm, who is, I believe, here pretty regularly under normal business. My background is I'm a graduate of the University of Pennsylvania Law School. I spent 2 years with courts, with the trial court and the appellate division. When I came into the firm, I naturally wanted to kind of be litigation and more sensitive side of things. I'm here to speak to you today because obviously we're here to discuss litigation that I was handling for the association. I also deal with kind of more politically sensitive issues like your relationship with your town in terms of municipal reimbursement, things like that. I've been with the firm for 10 years, and I'm very glad to be here. I will give an update to the membership on the litigation, and then we'll take question and answer. If you could please hold your comments and questions till the end.
So 1 second. Ed, can you turn up the volume a little bit, please? Okay, thank you.
Better?
Okay.
Do I need to say that again?
No!
All right. Okay. So obviously, you have a lawsuit pending against the association. It is an active lawsuit, so I'm not going to be able to answer every question that you may have or go over everything, but I certainly will try to explain the background for the lawsuit and the current status. So the lawsuit was filed in relation to your capital contribution fees. When somebody buys into your association, they pay a fee to the association to become a member. That primarily offsets your monthly maintenance contributions by income from new residents into the community. This current board, or the recent board, when they came into office, was posed the question of when somebody moves within the community, do they pay the fee? right? So if a spouse dies and somebody's looking to downsize, or for whatever reason you pick up a new hobby and you're looking to upsize your home, should you have to pay the membership fee when you're moving from one home to the other? The board considered that question. They looked at what was done in the past. They saw that in the past, that fee was refunded, so it was paid and then refunded in those instances where somebody bought a second home, then sold their first, moved, and then sold their first within a relatively short period of time. So the board decided we're going to continue that policy, that when people move within the community, when there are no members of the community that have a single home, only overlap with two homes for a brief period of time, we're going to continue to refund that fee. Plaintiffs bought a second home in the community and have held that home. We haven't really gotten to why they purchased the second home, but they purchased the second home and have held that second home. Approached the board and said, we would like that refund that you've applied for the membership fee. We don't think it's fair that we pay that fee to the association, and it should be refunded to us. The board considered and they said, no, this policy is only for people that move within the community, but plaintiffs did highlight a good point that this policy was not well explained to the membership. People might not have known about it. So let's put it in writing and let's record it so that people understand if you decide to move within the community, these are the scope of the exception and the refund. That is at the core of the dispute, is the refusal to refund the membership fee to plaintiffs on purchase of the second home. For whatever circumstances, plaintiffs happen to be the only people in the community at the moment that own two homes. So everybody else has moved within the community. You don't have any other single person owning two homes at the moment. Lawsuit was filed in December of last year. Yes. This core dispute of really, I see the lawsuit, the complaint is posing two questions. The first is, did the board have authority to waive the membership fee to the people moving within the community? You had 5 or 6 people that took advantage, or sorry, 3 or 4 people who took advantage of this policy and received the refund and were not required to ultimately pay the membership fee. Did the board have discretion to refund that, or was the board required to collect the fee from that? Were they compelled by your governing documents that they could not grant an exemption? And then second, in allowing them an exemption, did they also have to grant the plaintiffs an exemption from that membership fee, or was the board motivated by personal animosity or disparate treatment of the plaintiffs in denying their refund? So the complaint was filed. Count 1 is pretty in keeping with that idea of the board didn't have authority to do this and should be corrected. So that was breach of contract against the association only, demanding compensatory consequential damages and cost of suit. Count 2, unjust enrichment, is really cause of action for when there's not a contract in place, saying we're not sure what the contract was, but we think that this is unfair, and again, against the association only for compensatory consequential cost of suit. Count 3 was good faith and fair dealing. That's cause of action that says, well, you may have complied with the technical letter of the contract, but you didn't comply with the spirit of the contract, so therefore I should be allowed to recover. And again, that's against the association for compensatory consequential cost of suit. I think the real problem for the board was when we reached count 4 and 5. So count 4 of the complaint was breach of fiduciary duty. That was the first count that was pled against each of the trustees at the time. So that was seeking recovery from the people that were on the board at the time of the denial. It sought compensatory consequential cost of suit and punitive damages. Punitive damages are, if it's not paid for the word, essentially punishment, right? It's saying we think that the court should punish the defendants because they did something that was intentionally wrong or motivated by malice or animus or an improper motive. So that really takes it from kind of an academic debate over did the board have authority or not to an accusation that the board was motivated by personal animosity in denying the membership fee refund to the plaintiffs, and that the individual trustees should be liable personally for punitive damages to the plaintiffs. It's not uncommon to throw a demand for punitive damages into the complaint. I think part of what changed this in our eyes is that in addition to tweaking that, in addition to joining the trustees as individuals, so all 5 trustees that voted on that decision, the complaint also included a demand for discovery of their personal records and their tax returns. Because an element of punitive damages is understanding how much money they have, and in order to properly calculate a punitive punishment to them, so in theory, their tax returns would be relevant to that. The last count was recoupment of amounts owed, and that was essentially asking the court to compel the trustees at the time to pay in personally the amounts of the refunds that had been granted to the people that moved within the community. So rather than going to the people that moved and saying, look, we think that this was improperly refunded to you, it was go to the trustees and say, you decided to give them a refund, you should pay out of pocket because you do not have authority for that. So that's the complaint that the association received. The initial decision was, we recognize that there's a core dispute over whether or not the board had authority, but we do not think it is proper to join the individual trustees, and we don't think it's proper to seek these punitive damages and more aggressive parts of the complaint really intended to recoup the plaintiff's attorney's fees. So part of those punitive damages is that you tell the person that decided to sue, you get a refund of your attorney's fees because of the egregious conduct of the defendant. That's the main reason why it's pled, is that the court is intended to punish the defendant by ordering the defendant to refund the plaintiff's attorney's fees. So we filed a motion to dismiss, to say, look, this complaint needs to be shrunk down to a core cause of action. There's other technical arguments that were raised in those motions. The pleadings are public record. If you're really interested in the law and the aspects of this, you're welcome to look at the briefs and see everything that was argued, because I am oversimplifying some of this. We filed a motion to dismiss, saying this case needs to be shrunk. Plaintiffs responded with, well, actually, we think this case can be decided right now, very early in the case. So the association still has not answered the complaint or pled counterclaims. In a way, this case is very old because it's gone on for a long time, but in another way, it's very new because the association hasn't even responded to the pleadings. If they have not answered, they have not pled counterclaims. Plaintiffs filed motions for summary judgment saying, we think as of today, the court can make the call on counts 1, 4, and 5, and we would like the court to make that call. The association response was, okay, let's have the call made on counts 1, 4, and 5. Let's move this case along. So it got a little complicated, but basically we cross-moved for summary judgment. Both parties said, we think the record is set. We think the court can decide counts 1, 4, and 5 and grant judgment on this. Counts 2 and 3 were not moved by plaintiffs, so they were not moved by the association, so they are still open and exist. This is where we ran up against what's happening with the legislature, with the courts right now, and the shortage of judges. Those papers, I believe, were all filed by March or April, and then the case sat with the court because the courts, Ocean County in particular, are short on judges. They are waiting on the legislature to approve more judges. The judges that we know have an incredible caseload and an incredible amount of cases. This is a complicated case, and the court just wasn't moving it. So we had a few case management conferences. Talked about the motion, but effectively, the court was not moving the case for a significant period of time until it was finally scheduled really to be decided in September and October. We had a settlement conference in September. Settlement discussions are ongoing. There is a settlement offer out to plaintiffs at the moment. We're hopeful we'll resolve the case shortly. So we're not going to get into the details of settlement at this time. But we had a settlement conference in September. That was not successful in settling the case. We had an oral argument last week with Judge Ducey. The extensive oral argument, the judge heard the motions. Typically, on a motion like this, when the answer has not been filed, there's still discovery open. The expectation is the court's going to say, I'm not ready to decide this yet. I think you should go exchange records. So that was my expectation going into that motion, was that the court was going to say, sorry plaintiff, sorry defendant, I'm not ready to make the call on this yet. You guys need to go close out discovery. Come back when you you're all satisfied you have all the records you want, and then I'll tell you the answer. I was pleasantly surprised, both in that the judge was willing to make the call on the record on Thursday. And in that, obviously, he ruled for the association. So the judge's ruling was that the association's motion for summary judgment was granted as to counts 1, 4, and 5. So those counts are effectively dismissed with prejudice, pending plaintiff's rights to appeal. The judge also found that there is no genuine issue of material fact relative to the board having authority to act in the best interest of the association, and there are no questions of material fact that there was no disparate treatment of plaintiffs. So essentially the judge found that plaintiffs were in a category all of their own, of being a homeowner of 2 homes. There was a different category from people that move within the community. There's no evidence that the board treated plaintiffs differently for any reason other than the fact that they were in that separate category and that they made the call. So obviously we're very pleased with winning. I'm more pleased with having the courts confirm that my understanding of the governing documents and the case law was correct. But that is not the final call. Obviously plaintiffs have the right to appeal. That will still be open for a while. You also have these 2 remaining counts, which, as I mentioned, are unjust enrichment and breach of good faith and fair dealing, which remain open. I don't know how plaintiffs' counsel feels about this, but in my mind, the judge's findings on the counts 1, 4, and 5 basically make those counts impossible to win, short of reversal on appeal. So although it was not in front of the judge on Thursday, so the judge is not going to rule on those on Thursday, the judge's findings as to the facts, as to the board's authority, as to the board's disparate treatment, those are in the record. Those are findings for the purpose of the trial court that will hold for the trial court and really preclude judgment in favor of plaintiffs on counts 2 and 3. Now, as I mentioned, plaintiffs have the right to appeal, so this is still very much an active litigation. If plaintiffs choose to appeal, obviously that is their right. The way the courts are set up is we have 3 levels. Even though this was filed in special civil part, which is thought of as a faster and kind of lower tension court venue, in fact, I'm finding that it's moving a lot slower because of backlogs than the other areas of the court. But more importantly, findings by the special civil court have the same weight as findings by the Chancery Division, which is thought of as kind of the most senior and closely managed area of the courts. So you have your trial court decision on counts 1, 4, and 5. We expect the trial court to grant a similar decision on counts 2 and 3 if we can't settle this case out. Once counts 2 and 3 are decided, plaintiffs will have 45 days to file a notice of appeal to take this up to the appellate division. Appellate division, you get 3 very seasoned, very senior judges that sit in a panel, and you have 3 judges that decide if the trial court got it right. That is by right. So in New Jersey, courts, the legislature prioritizes access to the courts. They want to make sure that all homeowners and all consumers have access to the courts to answer questions like this. Like, does the board have authority to do this or not? And they also have, by right, the right to appeal. On top of that, there's the potential to petition the Supreme Court. I don't think that plaintiffs are interested in doing that, but they have the right to petition the Supreme Court as well, Supreme Court of New Jersey, to review the case. And the Supreme Court decides what cases they hear or not. So they would look at that and they would say, we're interested in this and we want to review it or not. And so as of right now, the association has not, as I mentioned, has not answered, has not pled any counterclaims. So this case is really so far just about plaintiffs' claims against the association, defending those claims, and what the course of action and what plaintiffs are going to do next on that. I do want to speak a little bit more generally. To me, a lot of what this case has to do with is how you're going to decide to govern yourselves. So associations are really set up as representative democracies. So your primary role is in who you choose to be on your board. Right? You vote for your trustees and you invest in them trust to make decisions for you. The board works by majority vote, so you have 5 people, so no one personality is dictating what the board does. But the way that the membership typically expresses themselves is politically, by who you vote for, who you tell your neighbors to vote for, and whether you choose to run and serve on the board yourself as a volunteer. You need to remember that the 5 people sitting up here are also homeowners in your community, They are volunteers who decided that they want to have a say in what's done, and they've been elected by vote of the membership to be up here. That's a tension with the homeowners' rights to file lawsuits, right? The homeowners have a right certainly to speak. You have rights for free speech. You also have the right to litigate when you disagree with the board. Governance by litigation is very expensive. It's where I make my money, obviously, as an attorney. It's when communities choose to litigate. That is a way that associations can run, where basically you're asking the courts to decide every issue that may arise. And some judges will respect the board's discretion, and some judges will say, you know what, I think that I can do a better job at governing this community, so I am going to impose my own opinions about how this should be run. And they will grant side cases against boards in those instances. So it is a way that communities can be run. It is a very expensive way. It's not a way that we want to represent communities like yours long-term for decades. So it's not a way that we want to represent our communities. We would rather that you not litigate with yourselves, and that we come to your election meeting once a year and do regular contracts, things like that. But it's a decision that you need to make. More importantly, the board is working on an amendment to your master deed and bylaws. That will be going for a vote of the membership. So that is another way in which you express yourselves, is that you set the terms of the master deed and the bylaws. I believe there's a lot of changes that are going to be proposed in that amendment. One of those changes is to say, look, are we going to adopt measures that will, in instances where homeowners decide to sue the association, will it potentially shift the cost of that litigation if they're not successful onto the homeowner? So when the association defends a case, whether it's with our firm out of pocket, or if it's a slip and fall that's defended by your insurance carrier, ultimately it comes out of your assessments, right? Every penny the association spends comes from an assessment, comes from essentially your monthly maintenance, occasionally a special assessment, or we're setting aside a little bit of reimbursement from the town. As insurance, it comes out of your premiums. So really, all of what the association does, it drives back to your monthlies. Now, in certain instances, the governing documents say, well, we don't think it's fair that the cost of this be spread out to all of the homeowners. We think that this one homeowner should pay the cost of this bill. The easy example is if it's work done on your unit by the association, that might be charged back on your monthly statement to the homeowner, because it's a cost that should be borne by that one homeowner. Another instance is if somebody doesn't pay their assessments and the association needs to do a collections action to recoup their assessments, that's charged to that homeowner, right? We don't want the community as a whole bearing the burden of one member's non-payment of assessments, because it's not fair. You all pay your assessments on time. You shouldn't have to pay the added cost incurred by somebody who doesn't. One of the amendments being put in front of you is if somebody chooses to sue the association and they are not successful in that lawsuit, should the cost of defense be spread amongst the membership as a whole, which is the default, which is how your documents are currently written, or should that cost be assessed to that homeowner? That is not currently in place. It's not at play in this lawsuit. It will not apply to this lawsuit, but it is a question being put to the membership by this amendment that you will need to vote on. If you want to deter litigation, then your answer is a vote in favor of that. If you want to preserve your rights to sue the association, that is a right that you have under our Constitution, and you would vote against it. And there's no judgment on that. It's how I, as I said, make my list. So you will have that amendment. I believe it's a master deed amendment, so it will need 2/3 approval from the membership. But we're hoping to have that up for you shortly, and we are also hoping that that will help to address some of your expenses and the issues that you've been facing with the community. Right. So that covers my presentation. We're going to take question and answer. The purpose of today's meeting is for you to be able to ask me questions, also to express concerns to the board. The board is not going to respond to questions because this is an active litigation, so I won't be fielding questions. Additionally, I may not be able to answer some questions. So obviously, I can't talk about privileged communications between myself and the board, given that this is an active litigation. I may also speak in generalities. I also want to remind the membership that plaintiffs are here. It is their right to be here to attend open board meetings. So you need to think about what you're saying, because I'm not your attorney, I'm the association's attorney. So you need to think about what you're saying, what you're asking, and I would ask that everybody please keep the question civil, please keep the statement civil. I understand that there is a desire to have a conversation with plaintiffs. The board and I and plaintiffs' counsel are talking about potentially setting up a town hall on that. We're not going to be doing that today. The question today is about your ability to ask me questions and express yourselves to the board. I don't want this to devolve into a debate between certain homeowners and the plaintiffs today. So today we're just taking question and answer from myself, or if you have any comments that you want to express to the board, please don't direct your questions or your comments to plaintiffs. As I said, we may set up a town hall to do that, but board meetings are about communications with the board.
So I'm just going to, the way we normally do this, people come up to the microphone, you state your name and your address, and then you're granted the floor. And at any point, the floor can be taken away, not that floor.
Yes,
And will fall through the ground. No. So, as we normally do, we'll start with, if you want to line up behind to ask questions to our attorney, please feel free to do it. We're going to rotate right and left. So we will start on my right. Please state your name and your address.
Philip Lucas, 3314 Deep River Lane.
Phil, you have the floor. You have the
Thank you.
floor.
Has the court issued an order dealing with the summary judgment motions?
Yes, I have the order here. You're welcome to look at it. What I said earlier about the court's findings, I read from the order.
And have they issued a case management order in addition to that?
I don't believe the case management order is up, but the judge did give us verbally a schedule. I think answers are due next Wednesday. Discovery demands are due about a week from that. And then we're to tell the court by November 19th, I believe, whether or not we're able to resolve the discovery disputes. Obviously, we're hopeful that we're going to be able to settle this before the association has to answer.
Since the court order is a matter of public record once it's entered, I would like the law firm to provide a copy to the association in order to distribute it to the members through email blast or the views, whichever. But I believe we have a right to know exactly what was put in the order.
Certainly. I'm happy to do that. I don't know if you maintain like a web page that they could upload it to, or wants to send it out by an email blast to everybody. But I'll send management a copy of the PDF. It's also eCourts has public access, so if you're interested, I'm not gonna offer to circulate the entire case file. But if you're interested in looking at any of the other filings, you can review everything by eCourts. But I will have the order sent.
And if the summary judgment motion was granted in favor of the individuals, we still have the pending litigation on 2 of the counts, is that right?
The summary judgment was granted in favor of the association against the plaintiffs. So the association won the counts 1, 4, and 5. The case is still open, has not been addressed, no findings by the court as to counts 2 and 3. But in ruling on counts 1, 4, and 5, the judge made findings of fact that obviously will impact how the court handles counts 2 and 3.
So the litigation will continue.
Correct.
Thank you.
Ronnie Santone, 3295 Springer. I have 2
Ronnie,
questions.
you have the floor. Okay.
I have 2 questions. I listened to your whole thing, and I'm just a little confused. So does this mean this is done now?
No. So we have, there's still I's to be dotted, T's to be crossed with the
Yes.
trial court. We have Judge Ducey's opinion and decision as to really the complaint pending confirmation on counts 2 and 3. Judge Ducey, though, is beholden to the appellate division, and the appellate division may feel differently. I have my own opinions as to the likelihood of success on appeal. As the association's advocate, you can take that with a grain of salt, because obviously I'm paid to advocate and win these cases. But the case is not over because the appellate division can review, and on a summary judgment like this, where the judge is saying, I have enough, I can make the call now, you don't need to do discovery. The appellate division basically has the ability to tell the judge, you know what, you're wrong, we disagree, we think it should have gone the other way, or we think that the party should have done discovery. Oftentimes the appellate division will say, well, you weren't right, but we still don't have enough to decide it, so we're gonna send it back to you, Judge Ducey, and you're gonna finish discovery and try again. And then we'll do another appeal. So it's still very much open, it's not settled as a matter of law because the appellate division hasn't spoken yet, and the time to appeal is still very much open. So we have the trial court's opinion on the merits of the case, but we don't have the full due process of court's final decision.
Okay, my other big question, because there's lots of rumors, can you tell me what this has cost so far?
You want me to do that?
Right, no, I can. So far, about 56,000.
So that's not covered by our insurance, that's covered by us?
Yes. That is spread among the community. Obviously, as I said, access to the court is a priority for the legislature. When the association is sued, it's a corporation. It has different rights than individuals. It needs an attorney to defend it. I don't know how much plaintiffs have invested in their side of the case. I don't know what their fee arrangement is. That has not come up. Never been discussed in discovery. But the association has spent $56,000 so far on this.
And we're not done?
Correct. That's why we're hopeful for something.
Thank you.
Adrian Sclafane, 2365 Braddock Road. Just
Adrian,
what
you
was-
have the floor.
Thank you. What was the initial cost that that started this whole thing? Was it $2,000? Is it $2,000 that you pay when you buy here? I don't remember what I paid when I
So-
moved here. What is the?
So as I mentioned, there's two parts of the complaint. There's we don't think that the governing documents give the board this authority. So that $19,000, $1,900, yes. $1,900 should be refunded to $1,900, so it was $1,900 to the plaintiffs, and then, 3 or 4 other homeowners who were given the refund at issue. There's a second part of the complaint, which was also, I think that the board should, and the association should have to refund my attorney's fees and pay punitive damages. So really, there was a small core complaint that, I found rather academic, and most people wouldn't pay to litigate over $1,900. I understood the dispute. There was a broader part of the complaint, which was very aggressively demanding punitive damages from your trustees, which really impacts association governance and politics, because when the people you elect are put under threat of liability like that, and their personal records and tax returns are demanded, that influences how the association is run. That part of the complaint, to me, really ties into a history of how plaintiffs have interacted with the association via legal counsel that, when I look through the records, dates back to prior counsel for the association and kind of an ongoing course of approaching disputes with the association through legal lens and attorney hands.
My other question, did our board members have to show their tax returns, or was that deleted when something was dismissed? Did they have to show their tax returns?
So we refused to produce the tax returns.
I hate it.
We refused to produce the tax returns. There is case law that says that tax returns are only to be shared in really heightened circumstances. The court didn't reach it. It's unlikely to reach it now because having won on counts 1, 4, and 5, it really it dismissed the claims against the trustees as individuals. The remaining counts 2 and 3 are only against the association. So the trustees are out of the case as individuals. So the court will never have to reach the question of do they have to produce their tax returns.
Okay, thank you.
This side, please.
Vincent Daniels, 2781 Lennox Street.
You have the floor. Thank you.
I wanted to know if, in the end, when everything is decided and the association wins the case, is there any consideration to recovering our attorney fees from the plaintiff?
So There are causes of action, your current governing documents don't, so normally, your only shot at recovering attorney's fees in a case like this are because the contract between you says that you get that. In your circumstances, that contract is your governing documents, and your governing documents don't provide for that currently. So that's the amendment that we're potentially talking about putting in front of you for a vote. There are causes of action that would potentially shift attorney's fees. They are very disfavored by the courts. We try not to bring them because courts judges really do not like seeing them. They treat them as an unnecessary escalation. Even if you win on the facts, the court can still cut down the amount of the attorney fee award, so even if you're successful on the cause of action. So those counterclaims would either be pled with the answer that hasn't been filed yet, or after the lawsuit is over. So some of those counterclaims, you have to win the case in chief outright first, and then after that case is over, you have to then go file another lawsuit and pay more attorney's fees to recover your prior attorney's fees. We don't like to do that. That is going to be a board call. I'd rather not litigate those because a lot of times they're throwing good money after bad. So the answer, it's not no, we're not going to do that, or we can't do it. It is a possibility. It's one that we haven't addressed yet. That'll be addressed either in the answer or after the case is over in potential filings. We're hopeful that this will settle up and that both parties can walk away and move on with their lives.
Thank you.
Louise McInerney, 2373 Woodbine Lane.
Louise, you have the floor.
On his note, can we as individuals form a group and sue for damages?
So I can't give you legal advice.
Why not?
Because I'm not your individual attorney. So my code of conduct says I have to be careful in who I give legal advice, because if I give you legal advice as an individual or a group, I effectively become your lawyer. You have the right to speak. You have the right to express yourself. You have the right to access to the courts. If you want to know about what causes of action that you may have, you need to talk to your own attorney. I don't see a cause of action that an individual homeowner would have. I would also tell the association in general that use of lawyers to express yourself and use of lawyers to address disputes you may have between you or with the board, as opposed to expressing yourself by how you vote or via the ADR system or just common civility. Use of lawyers is very expensive. So that includes if some of you decide to hire your own lawyers and sue each other or sue the association, you will make a lot of money for me, and you will not make a lot of money for the association.
And you don't think we could, you can't answer that, all right. So you're advising us all to remedy the situation as best we can so it doesn't happen in the future again.
Yes, that is my advice to you as the membership in general. The amendments that we're discussing, they are not standard for the industry, but we are seeing more and more associations that are running up either defense costs or insurance costs. Obviously insurance, I'm sure, is a big discussion point for you with the cancellation last year. We're seeing sites run up those costs and having to take the drastic step of saying we really need to amend our core constitutional documents to address this. We want people to have justice, but we can't keep litigating everything. So that's a question we're putting to the membership, right? So you're all going to decide how to vote, and I will live with the consequences of how you vote. So if you decide not to vote for this, obviously that's your decision. My advice to you as the membership in general is this will disincentivize
Wait, I can't hear you, wait a minute. Go on.
My advice to you in general is the amendments proposed will disincentivize litigation and use of the courts. They're intended to incentivize people to vote to achieve change in the community rather than to sue to achieve change in the community. So if you're in favor of that, then you would vote for these amendments.
Okay, now, so we are going to be raised at least, if we stay at the 50,000 number, we're going to be raised $5 a month on our HOA to cover the lawsuit. That's the mathematics of it in broad numbers. So what you're saying to us is we gotta just let it go. Pay the $5 a month for a year so that we can recoup the funds and let it go.
Well, as things stand right now, the board and the association does not control whether to let it go. So as things are right now, the association does not have any pleadings or claims before the court. It's really in the plaintiff's control to decide whether to continue to litigate or to drop those claims. So I don't get to make the call on let it go or not let it go. If plaintiffs decide to continue the litigation, I'm going to need to discuss with the board whether we're going to pursue counterclaims. Frankly, I haven't gone through the details and thought out what claims may exist, because I'm hoping to avoid that. But yes, my recommendation to you is if you can stop litigating, then stop litigating.
Okay, I'd like to know if any of the board members have experienced any financial burden from all this stress and this terrible situation that they've been put in.
So I assume the trustees have the same financial burden that you have and that everybody shares equally under the current governing documents expense. I believe the board is looking at doing a one-time assessment because you've had a number of unbudgeted, unplanned expenses, including the situation with trash reimbursement. So rather than defraying this over putting into your regular maintenance, I think the board is thinking about doing a lump sum assessment to make up both this litigation cost and other costs. So I don't think it's going to be a monthly, or that will be a raise in your monthlies reflected. I do know that on a personal and stress level, obviously, people really don't like being sued individually. I think it's understood that the association gets sued occasionally. Certainly slip and falls happen all the time, and the association is used to being sued. But as volunteers, it is incredibly stressful to be sued. It is incredibly stressful to receive a demand for your personal records and think about, have an attorney tell you that you need to think about how you would testify under oath on this, that, and the other thing, and have you satisfied your duty to collect and produce records? Are you preserving all the records that you need to preserve? Examining your own conscience on what happened, and did I really vote completely independently of my personal feelings or not? Yes, that is extremely, I'm sure it's been the source of many sleepless nights for the trustees that were sued. In addition, I don't think that the board that was sued is entirely this board. So some of the trustees that were sued are no longer on the board, and I know they in particular found this very stressful and are very relieved to be out of the case. So I'm glad to be able to have that for them. But
So can we pass the hat and give the board members some money for comfort?
no, that's up to them.
Well, my address is 2373 Woodbine, and I only accept cash.
Thank you. I would say I think everybody would love cookies or invitation to a home cooked meal.
So to get down to the bottom line, this board is going to have to, or you're going to have to discuss paying back the defendant $1,900, and that's it, right?
So the court more or less decided that and said that the association does not have to pay it back. So the trial court decided that and said that the association does not need to refund the plaintiffs the $1,900. I'm generalizing. The appellate division gets to review, but Judge Juicy said association does not need to refund the $1,900 to plaintiffs.
But then what negotiation still exists then?
So we have the right to appeal, and we have these two claims that weren't presented to the judge that the judge needs to, in my mind, effectively the judge just needs to sign off that those claims are also found in the association's favor.
And are those financial claims?
It's essentially just the same claims as the breach of contract. They're just slight modifications of the same theories.
So there's no money involved in those two points. I was just reading it and I couldn't see that there's money involved.
So
it's her legal fees, right?
the rest of the demand, the punitive damages, So I think what you're asking is, on the summons, this summons, so when you're served with a lawsuit, there's a complaint that tells you what you're being sued over, and then there's a summons that says, you better show up in court, because if you don't, we may enter judgment against you. The summons includes a demand for $20,142. That is the cap on what you can get in special civil, plus the filing fees that you can get in special civil. So that really doesn't reflect any specific amount. It's really just the most that plaintiffs could have gotten in the court that they were in. But as I said, I'm oversimplifying, but at the trial court level, the court has effectively said, association wins, no damages, no judgment in favor of the individual trustees. I take it that you're one of the individual trustees that was sued?
No.
No, okay. So no judgment against the individual trustees, no judgment against the association. Plaintiff can appeal if they want, but the trial court has spoken, and there's no liability to the association or the trustees.
Okay, and I want to apologize to the board and to Carol and to Charlie, if you're here, for all the grief and whatever you went through. It must have been harrowing. And I personally would like to make it up to you somehow, but I don't know how.
All right, we're gonna move this along. We've got this side. Please state your name and address.
But right before you say it, I'm sorry, I just wanted to let you know it's been around a little bit over 25 minutes.
Okay, so
Q&A, just for
All right,
time.
anyone who's online now will do. No one else will be added to the line, okay? Is that fair? All right, well, this side, name and address.
Brian Lilienthal, 2924 Crestview.
Brian, you have the floor.
Thank you. So you mentioned before about prior legal actions taken by the plaintiff prior to this situation.
Sure. So I should clarify that. This is the first time that, to my knowledge, there's been litigation between plaintiffs and the association. Previously, there was use of ADR, which we encourage. So ADR is basically mediation. You sit down, you have a dispute, you sit down and you talk it out between them. If you can come to an agreement, you do, great, you move on. If you can't, both parties walk away from the table and you can go to each other or whatever. So there was ADR. There also was a lot of legal communications. Obviously, when the board tells me to send a letter to a resident on legal letterhead, that's a little different than an email from management or a letter from the board. Obviously, I think it's actually very different. There's an implicit threat in having your attorney say something as opposed to you saying it yourself. When I send a violation notice to a resident or a collections notice to a resident, they're going to pay a lot more attention to that legal notice than if it came from management, because it's just by the fact that it's on attorney letterhead. Now, I hope when I send a letter to the resident saying, hey, you're all invited to the block party, you don't feel bad. But the fact that it's on attorney letterhead does include kind of an indication of seriousness. So the prior relationship was a lot of legal correspondence between attorneys. So even before this lawsuit, you were spending attorney's fees on having your prior counsel write letters back and forth about disputes.
Do we have any idea how much those costs were?
That I don't know. I'm sure the board has the records.
So basically what I'm thinking is what was it, $56,000 that we've already spent? I want to know what total amount, what we have spent as an HOA prior.
Okay, it's approximately $14,000 or $15,000. So that was before this litigation. So if you're asking for a total,
I'm asking for a general.
ballpark 70.
Okay.
All right, we'll go on this side. Name and address, please.
Joanne Greenberg, 2931 Crestview Lane. I appreciate
Joanne,
you
you have the
being
floor.
here. Thank you, Mike. I am sorry for what everybody has gone through, us as well, because I think it's a very selfish and unnecessary action personally. I have two quick questions. One is every association has a line item within their budget for litigation. Does ours?
I don't believe you do.
Okay. Previously, we had legal fees for things like amending our governing documents and also our bylaws, and that comes up, we only did that, what, 15 years ago? So typically, there's not a lot of money that's put in there because we don't expect to have any expenses like that.
Of course.
So kind of got caught off guard with that.
Okay.
So,
As of right now, you have a line item for legal, but that's intended for your contracts and amendments. You don't
Your
have a
basic-
line, right, you don't have a line item for litigation defense.
Okay, thank you. My second one, and I apologize, I was unavoidably
I'm
late.
sorry, I had to correct myself. You do.
you do? Right.
We just added a line item for legal defense. The legal previously were general legal fees, which took care of a lot of the bylaws or anything we would take care of, retainer fees. But to keep an accurate accounting, the finance committee worked with the accounting department to add a legal defense line item.
Okay, so in future, moving forward, you have that as a line item.
Okay,
But the expenses to date were really funded out of your contingency.
thank you.
contingency
I
line.
have just one quick one. I apologize for being late, it might have been spoken about, but it was told to me, and it could be a rumor, that in order for the plaintiff, in order for us to have no further court, higher court with this lawsuit, that the person who's suing us signed something that then we wouldn't have to pay their legal fees. Is that true?
I'm sorry.
I was told that in order for, that we were being threatened that it would be continued to go to higher courts. And in order for that to not happen, we allowed them to sign something that, that they wouldn't have to pay us any of the legal fees that we put out. Is that true?
I'm not aware of any such document. A settlement agreement between the parties would include resolution of who pays whose attorney's fees. Typically, when you settle, especially in an early stage of the case, each party agrees, I'm gonna pay my own attorney's fees, you're gonna pay your own attorney's fees, we're gonna walk away if money changes hands over the damages, it changes hands over the damages. I'm not gonna get into the specifics of what the current pending offer is. If it's accepted and finalized, our position is that the membership have a right to understand after the fact that it should be confidential because it has financial repercussions, but we're not gonna talk about it now. I'm not aware of any such document that would bind plaintiffs that would say, we agree that we're not gonna pursue our attorney's fees for you.
Or that we're not gonna take this litigation any further to any higher courts?
That would be the settlement.
Okay. All right, thanks.
Please state your name and address.
Lou Scaltrito, 2742 Brookdale Court.
You have the floor.
I have a question. You mentioned about insurance, us losing our insurance carrier. Was it based on this litigation or multiple litigations?
I don't know the specifics. I assume that was your general liability carrier, which would be mostly a decision based on what's going on nationally, the state of your site, concerns they may have had about specific maintenance issues. I honestly don't know. Usually it has a lot to do with the carrier.
So you
wanting to
can't
reduce
say
risk.
it's this litigation.
I don't specifically know, but I think it is pretty safe to assume that it had nothing to do with this litigation.
Okay, thank you.
My name is Mary Nagliki, 2933 Rock Hill Lane.
You have the floor.
I was surprised why this issue was reached at this end. I feel sorry for the board member because they're all volunteers. But my point is, why the plaintiff and the board was not able to settle so we don't have any court case, we don't have to spend money. I don't know what happened. That if there's a problem, for example, the plaintiff is asking for a certain refund or whatever, and it's not in the Constitution. If you think the plaintiff is wrong, you can explain to them. If we are wrong, why not just give in so we don't have to reach and spend this amount of money?
So,
And I'm just telling this so that next time it will not happen again. If there's something that you could settle it. You know, you don't have to have a court case. That's all I need to say. Thank you.
So the issue is, everybody that comes to the board asking for money does not get money. right? If I come to the board and say, I would like $2,000 because I'm amazing, please approve that, the board is not gonna approve that, and then I say, well, I think I'm entitled to it. And the board says, no, you're not. The board can't settle every demand in favor of the person making the demand. And there are always going to be disputes that can't be settled. So the way that those disputes are resolved are via the courts. So if they can't be settled, then it needs to go to court if the plaintiff wants to pursue the demand against the association. We would like the association to settle all of its cases, but a settlement takes two parties. Both sides need to agree, and we're not going to talk about the nuts and bolts of settlement on any particular case, but I can't make the other side agree to something that is acceptable to the board. The other side can't make the board agree to something that's unacceptable to them. So both sides need to reach that middle ground, and if they can't, then you have, and the rest of the membership currently have the right to go to the court. So I understand you want cases like this to settle, but it is two parties that both need to work together, and that is not always possible.
I know, that's why I'm saying, if the plaintiff is asking something that is not in the Constitution, they have to explain to the resident. But if you think that we make a mistake because it's not in the Constitution and the resident has the right to complain, why not just the HOA just give in, so that we don't have, I mean to say nothing in.
So I'm going to respond to that, and then we're going to
Because
move
I'm
on.
thinking, now we reach the too expensive. So I'm thinking that we could just settle it if you think the board is right.
So I would like to answer that, but then we're going to move on. We're going to continue discussion. I think the board was right.
Okay.
In that the fee was not owed.
Okay,
The court,
is right.
ma'am, you gotta let me answer, and then we're gonna move on, okay?
Okay.
I think that the association was right. My colleagues who were helping the board with this thought the association was right. This was within the board's discretion. The court agreed. So the court said, Judge Ducey said, the board was right. Okay? So in those circumstances, it's a tough call, but the court has got to decide, are we going to pay those claims in future via settlement? Or are we going to say, this is what our governing documents say, and we have been elected to make these decisions, and we are going to make these decisions for the membership, and not settle demands that we think are not properly paid. So
if the board is right, I'm saying if the board is right, we have the right to talk to the plaintiff, but this is too far that we are spending a lot of money. That's why I'm saying if we could just make it short so that longer run.
So, all right, Michael.
Okay, thank you.
Is this okay? Okay. But we're done with the.
Elaine Serta Morrison, 3616 Perry Ave.
Elaine, so it's a question to me, this is not opening to public debate and comment.
And 2847 Roseville Court. My question is, why wasn't this just simply put through the insurance?
Yeah, so the association maintains different insurance policies. One of those insurance policies is what's called the Directors and Officers Policy. It's there to defend the association in case of lawsuits challenging board decisions. There was potentially coverage under that policy. The decision on whether or not to put a claim into that policy rests with the board. I don't know the nuts and bolts of your policy as to whether or not there would have been coverage for this claim on that. Obviously, usually there's retention. More importantly, when the DNO does decide to defend a case, they have their panel of attorneys. They have the ability to influence how the case is litigated, and the law firms that do that work, we do not do that work for insurance defense firms at the rates that they will approve. The law firms that do that work are not our firm. They litigate the way they litigate. Some of them I respect, some of them not so much. So the board thought about that. In addition, obviously putting a claim into your insurance carrier, all those defense costs go into your loss run. So the carrier tracks every dime spent on attorneys. Though insurance carriers are in the business of making money, so they will find a way to make that money back in the association, principally via raising insurance rates or potentially canceling coverage if there's too many lawsuits put in. So I know that you had, I believe, your general liability policy canceled last year, which is different from the DNO policy. But there's a lot of concerns right now about availability of insurance policies. The board must maintain insurance. That is in your governing documents, is required. So the board needs to make sure that insurance is available, and the board also wants to minimize the chance that it has to put excess lines policies, which are vastly more expensive if the standard carriers decide to drop the association. So there's a lot more details that I can't get into in this moment about the board's decisions on insurance and what to make insurance, but generally speaking, that's the answer.
So earlier this year, Alan Main specifically asked the question if this is going to be put into the insurance, and Ray Barnes' answer was, once it goes to trial, it will be put through the insurance.
I wasn't there for that question. I can't speak to that question.
He absolutely said that.
Okay, so the answer is I don't know the circumstances of that question. I can only answer the question posed in front of me today. We're not gonna engage directly. These are questions to legal, so please hold your comments. Please hold your comments now.
Please step into
Ma'am.
So seven residents in Lake Bridge did receive the $1,900 refund. I am the only one that was refused.
So the board is talking about potentially doing a town fair. If you would like to speak with the board and the membership about this, I think today we have to move on. I don't want to make any questions.
Okay, and it also needs to be known that for 11 months, my husband and I did try to negotiate this with the board. And other residents.
So we're not, this is not membership speaking, and the question of the attorney, thank you for coming and speaking.
And my attorney is here, if anybody wants to ask my attorney questions. He is here, I'm looking for questions.
Notice I had to lower that a whole lot of way. Okay. I'd like to thank Dave Merritt for being available. Now we will move on for the normal course event, and I promise this will be brief because we realize that this has already taken a fair amount of time. So we'll now go on to the President's report. I'm going to make it real quick, all right? There are no motions for today, so that makes it even quicker. There are no concerns in regard to the pool. There are no concerns in regard to the gym. These are things I normally report on. Annette will be reporting out on the work and time schedule for the amendments to the HOA bylaws that David mentioned. And also Annette will be discussing, we're reporting on the Lake Ridge new sign project in an effort to decrease speeding, which has been a problem forever. Ray will be reporting out on several things to include the most recent articles on the structural integrity laws and the recent article that was put in the paper that a lot of residents questioned on. Mary is going to give the financial report, but as part of that, we have Steve Agresta, who is on the Finance Committee, that will be doing a brief report out to give you an update on something. I'm done with my report. So we'll now move on to Ed's Vice President report. Ed?
Thank you all for coming. It's been a very interesting meeting so far, and I hope we can draw it quickly to a close. One very gracious moment to change the mood of it is to ask Phil Weiner to stand up. Phil?
I didn't do anything.
Phil has done a lot, and it's at this time that I'm very happy to express our thanks to Phil for the work he's done as chairman of the ARC committee. As you all know, as we all know, it's a very important and very sensitive and often rather difficult job to take. But Phil has done excellent work on it with good humor, and so I think we all owe a great deal of thanks to the ARC man, Phil Weiner. And I would also like to report that the ARC committee will be in good hands because it's going to be chaired by Charlie Rock, who is well experienced. He has served on the ARC before as chair, and so there'll be a continuity in the administration of the ARC committee. So thanks to Phil, and good luck to Charlie Rock.
So thank you, Ed. We will now move on to the Treasury report from Mary, and again, Steve Agresta will be sharing some information with you. So, Mary?
Unfortunately, the numbers are not finished yet for the month. There's a lot of tweaking being done to get the budget in line. But in the meantime, Steve has something to tell us about how we have to, history of the money from the money that we didn't get.
Right. What she's trying to say is we have a contingency write-off or a charge, and I'm going to walk you through a little bit of history and then what we're doing and explain it to you. So you may have heard some of this information because it is related to the trash collection and the switch recently to the township.
Mike needs to be closer.
Okay, better?
Yes.
How about that?
Yeah.
Okay, so in the past, trash collection was through a private company and not provided by the township. Trash collection costs were reimbursed by the township to Lake Ridge under a municipal services reimbursement agreement. For many years, probably from the beginning, I guess we have always had waste management. For many years, the township reimbursement covered the full cost Lake Ridge paid to the private trash collection company. But more recently, maybe over the last 5 or 6 years, the cost of the private collection exceeded the amount that the township was able to reimburse under the municipal services reimbursement formula, and an annual cap was instituted. So they would only pay a certain amount, whatever it cost them based on the formula, and they wouldn't pay any more to us.
Move the mic up.
Okay. You may recall this is one of the main drivers behind the switch to the township trash collection services earlier this year. When we processed, and I'm going to simplify this because it's a lot of accounting, but we put the money that was owed to us in a receivable from the township. So we paid the trash hauler expecting to get our money back. As a result of the annual caps that were never communicated to us, and during COVID, there was a lot of delays in processing reimbursements. So it would take, I think it took up to a year, right, in some cases, to get our money back. The documentation wasn't clear as to what they were paying, for what periods, and how much. So it got a little bit to be a challenge to keep track of where we were and what was owed to us. As a result, we were never paid approximately $50,000 in waste collection costs, and those costs will have to be written off.
What does that mean?
That means we have a receivable or an asset on our balance sheet that we will not collect on. It's as if someone owes you money and you're not going to receive the money. It's not gonna cost us in terms of cash out of the bank because it's already paid. It's money that was due to us that we're not gonna receive. Well, I'm gonna tell you. Despite repeated attempts by our attorneys and the board, the township will not reimburse Lake Ridge. And I think you may have a little bit, David was involved earlier with the communication to the township in an attempt to recover some of that.
So for my sins, one of the other things that I do for our communities is I litigate with municipalities over this municipal reimbursement. The standard you see in most towns is for trash collection. Towns, the law has a cap on the reimbursement they owe. Your town has been very generous in the past on reimbursing you for trash. In most towns, town is paying about half of the trash and recycling costs. And they also typically don't pay it until 6 months into the following calendar year. So basically the association fronts the cost of trash collection for that year, and then 6 months later they get maybe half of it back. For years, your town was paying 100%, which is great. They really didn't have to pay 100%, but they were. I don't know how, it sounds like they're also paying it fairly quickly, and the association and the board got used to that and budgeted around that. Shortly after COVID, a lot of towns had election results where the members, they felt like the mandate from the citizens that elected them to the board or to the town council was to cut expenses, right? Tighten the belt, keep taxes down, no tax increases, which means that all the staff of the town were under instruction to look and find ways they can cut costs. This is one of the areas that they can cut costs, that they looked at this and said, we're reimbursing Lake Ridge and all of these other private communities at 100 cents on the dollar for trash, and we don't have to do that under the law. In fact, we can save the town $50,000 by not paying it to Lake Ridge. So in that context, they said, okay, we're not going to reimburse Lake Ridge that $50,000 because we don't have to. Obviously, that has had consequences because the board has to budget in advance, right? The board has to make assessments based on what they expect to happen the following year. We talked about litigating with the town. I have sued towns on similar claims. I have sued Jackson on similar claims. I have won those lawsuits. I have sued towns on those claims, and I have lost those lawsuits, right? There's no fee shifting in any of those cases. So you pay out of pocket to challenge the town's decision, and typically, as they say, you can't fight City Hall. So we talked with the town, we tried to convince the town to work with us. The result was that the town said, look, we're not giving you any money. You want money, you gotta sue us. But we will start doing your trash. So you were being fully reimbursed before, we're not willing to do that. It costs you a lot more to hire Waste Management to pick up your trash than it costs our DPW with our DPW staff to pick up trash. We're not willing to pay for Waste Management service anymore, but we will give you our DPW service. So obviously the standards of service are different when you have a private vendor that you're paying a lot of money versus your local staff. But the town's offer was we will provide the service so you will be able to not have to include this in your budget moving forward. That was a good result. The town doesn't actually have to service communities like yours. The town can say, first, we're gonna dictate amount of reimbursement to you, and we're not even gonna offer service. So that's within the town's rights. So the town made that offer, and we think that was a good result. Unfortunately, for the years between when the town made that offer and we were able to implement it, you were paying out of pocket for Waste Management on your budget, you were expecting to be reimbursed from the town. So some of this goes back to 2022 and was not really revealed to the board and discussed with the membership until 2024 that the town was going to cut the reimbursement. So as a consequence, we've got about $50,000, maybe a little bit more, that was spent that was not assessed in the budget. So that was paid out of the contingency fund. The result of all of this is that you maintain the contingency fund. I think it was about $150,000 for unbudgeted expenses, and it's been spent out significantly. So that's one of the things your board's going to be talking about in the coming months and today as well. But that's the background on the municipal reimbursement.
So, just kind of following up on what David just said, to do the write-off, which is the 50,000, with the least impact on the homeowners, the board and the finance committee have decided to use the money in the contingency fund. The purpose of the contingency fund is precisely for this type of one-time special unexpected expense. Currently, the fund has about $166,000 in it. So we are funded for these types of things. We will reduce that number, but we'll still have more than 100,000 when that write-off is processed. And just following up on the impact to the maintenance fees, the write-off will not impact our HOA fees in terms of maintenance costs. That is, again, a receivable. We're not collecting. We have a number for trash and other utility services that we budget for. This will not go into our annual budget and will not raise the HOA fee.
So the old crack fund is being utilized as opposed to passing the charge on, because as you know, every year things get more expensive. Electric, gas. Did you get your car insurance bill lately?
Yeah.
Okay. Anyway, so the board made the decision, along with finance, to reduce the contingency fund at $50,000 to avoid any further pass down to all of us of paying it. So that was a good thing. Okay, so then we heard from Ed, we heard from Mary. Matt is not here, so we will not have a secretary report, which now we have 2 more reports to go. So we have the director at large report with Annette, where she'll be discussing things like the bylaws and the other project that she took on. Okay, Annette?
Hi, everybody.
Hi.
So I'm here to talk about the amended bylaws and the vote that's going to be coming up. On or before October 31st, you are going to be receiving a clean version of an updated bylaws, a sample ballot, a proxy, and a cover letter. Those of you who have signed up for e-voting will get it electronically, and those of you who have not signed up for e-voting will get it electronically. So we should be having that by the 31st of October, hopefully. A town hall meeting is scheduled for November 3rd with Kevin from McGovern, who will explain everything that you have questions about in the bylaws, any amendments, any changes. The vote will start on November 17th. It will end December 17th. The votes will be counted on December 18th and hopefully have an outcome by the 18th or 19th. The votes will be counted by the the elections committee. And that's all I have to say about docs and policies. The next is traffic and speed control. I don't know if anyone has noticed, but there was a radar sign that was put up on Morningdale, and then it was moved over to Cedar Lake. And I thank the Toms River Police Department for allowing us to, I'm sorry? Oh, Clear Lake, I'm sorry. Clear Lake. So I thank the Toms River Police Department for allowing us to borrow those radar signs. I would like to eventually get our own radar signs so that we don't have to depend on the Toms River Police Department. We have purchased about 12 speed signs that eventually will be going up, hopefully before the roads freeze. Some slow down signs, and hopefully that will help with the speeding issue that we have in this community. That's pretty much it for speed and traffic. Thank you.
Okay, thank you, Annette. We'll now move on to the manager's report, which will be done by Ray.
All right, first to piggyback off of Ed's announcement regarding the Architectural Review Committee, we do have an administrative resolution to read off real quick that the board will vote on. This resolution is made the 23rd day of October 2025 by the Lakewood Homeowners Association, by and through its board of directors, having and addressing the care of Taylor Management Company, 2251 Lakewood Boulevard, Toms River, New Jersey. Whereas the amended bylaws, Article 4, Section 1, provides that the property, affairs, and business of the association shall be managed by the board, which shall have all those powers granted to it by the Articles of Incorporation, the Declaration, and these amended bylaws and bylaw. And whereas the amended bylaws, Article 9, Roman numerals, I had to figure it out. Section 1 said that the board shall establish an architectural review committee consisting of 3 members appointed by the board. And whereas the current chairperson of the Architectural Review Committee has announced his resignation, the board wishes to appoint a replacement. Now therefore be it resolved that the current ARC chairperson, Phil Weiner, had announced his resignation effective October 16, 2025. Charles Rott is hereby appointed as chair of the ARC Committee effective October 23, 2025. Mr. Rott shall serve in accordance with the amended bylaws and any superseding versions of the association bylaws duly adopted by the association. Should any provision of this resolution be deemed invalid, the remaining provisions hereof shall remain in full force and effect. Any provision contained within any previously adopted resolution of the association that conflicts with any provision set forth herein shall be deemed void, and this resolution shall be governed. Therefore, to duly adopt this resolution on this date, I ask for a vote from yes, no, or abstain from the Board of Directors. Michael Messina?
Yes.
Edward Whitman?
Yes.
Mary Adler?
Yes.
Matthew Bellicano? Absent. Annette Bailey? Therefore, by affirmative vote of 4 yes, no no's, and 1 abstention, the resolution is in fact appointing Charles Rott, the new Architectural Committee Chairman.
Thank you, Charlie.
And I'll try and get through this management report as soon as possible. I know we've been here most of the day. Just on some of the maintenance projects going on, Quality First Group had completed their work for the 2025 concrete replacement project. Final inspection was completed on the homes that were approved during the proposal. The project called for the replacement of approximately 4,600 square feet of sidewalk hazards at a cost of $74,692 that are out of the reserves account. Now, they were some, as in any project, there were some damages there. Any and all sprinkler heads that were damaged during the project were replaced. However, there was some problems with the irrigation lines that were wrapped up in the tree roots. And the people who did petition about this were notified that in the contract there is a disclaimer that any irrigation lines that were encumbered by the tree roots within 1 foot of the sidewalks was not covered by damage due to the tree and the time that the tree took to cover up the irrigation lines. All other complaints were settled. The 2025 tree removal of 14 dead trees in the common areas was afforded to Falkenberg Tree Experts for a price of $4,319. It was completed last Friday. Again, these are annual projects. We do announce ahead of time. We do go by concern sheets to get the list of these areas to be reviewed for repair. We still have the revised proposals for crack fill repairs on the roadways. We went back to get some exact measurements on the asphalt walkways as far as adding some replacement, not only the crack fill. We have three companies who are bidding, and that'll be reviewed by the board. We still have time, and colder weather helps out. So that'll be reviewed at the next workshop for board approval or discussion. Irrigation repairs were on the rise, as it is a 30-year-old system. I mentioned that before. We experienced a couple of extra repairs this year that we weren't looking at. However, the system started shutting down as of October 13th, so we won't be spending any money on irrigation for the next 4 to 5 months. And 2 bids for repairs were looked at for the riprap channels in the Clear Lake and the Falcon detention basins. Meticulous Landscaping was awarded the project for $9,600, tax included. We finished, as far as the office, compiling our reports and figures to contribute to the Finance Committee for the 2026 budget, and they are eagerly working on that for our benefit. That is a work in progress there. So what I really wanted to expound tonight, and today I'll try to be as brief as possible, is that there was a concern over an article in the October 11 Toms River Times regarding the structural integrity law. This law has been discussed since 2024 in New Jersey. It has been working its way across the country, and it was crafted after the Surfside condominium collapse in Florida back in 2021. If you remember that, 98 people died in this multi-level complex, basically because needed repairs were pushed off from year to year, and there were not adequate reserve money in their account to satisfy or complete any repairs. Studies found that there are more communities, condos, townhomes like that than we want to believe. The Toms River article expressed their concerns because of the rising costs this may or may not occur, especially in Ocean County, where you have a predominantly senior population. People are on fixed incomes, but it goes across the board for many communities in the area, whether it's townhome, active adult, condo, or an HOA, just as this community. And basically what it is dictating that community association boards at least have a capital reserve study every 5 years to make sure that they're adequately funded for these repairs. Capital reserve study, we would call in an engineering company that would go through the common elements, amenities in the association, look at their useful life remaining, how much it would cost to replace that, and then work that over a 30-year period to show the board, finance committees, the people in charge of the association, how much money should be invested each year to actually repair these damages, upgrades, so that this type of accident does not occur. And granted, the people in this article, although we hear it a lot in the management industry as far as costs incurred, this has been talked on for a long time. Not since 2021 with this condominium, but most communities, management companies they have to instill it in their boards to make sure that these capital reserve studies are done. And the common theme is every 5 years. I'm happy to report that Lake Ridge, through its board of directors, its finance committees, has this reserve study every year. Every year before the budget's done, we call in the engineers in here and upgrade everything we do. For any project that was done this year, we'll upgrade that in the report, and it'll go from maybe a 2-year useful life back to a 30-year useful life, so that the less money we have to contribute to that particular cause is invested, and we can keep up on the other causes. Also explained in your when the annual audit is done from our accountant Wealth and Good Plan, it is always announced, and it has been for the last three and a half years I've been here, Lake Ridge is in the top 2 to 5% as far as being financially invested. You guys are in a great position. Your board, your finance committee are very attentive to these details. Granted that this article, this structural integrity and reserve law, funding law, is a concern across the country, but it minimally affects Lake Ridge with the way that your board and finance committee have been working. If you have any particular questions about it, I'd be glad to answer it for you. But I'm here to say, from what we're looking at, from our records and from the practices of Lake Ridge, you're all in good condition. I'm good. Fine.
Okay, so when that article came out, there were several phone calls that came to the office. People, why are we not talking about this? Because we've been doing it.
Yeah.
Not every 5 years, every year. And talk about structural integrity, we spent $350,000 shoring up the walls of this building and the annex that were falling apart. We were on top of it. So for those that are worried, oh, the value of my house is going down because of this, that, not the situation here at Lake Ridge. So, and I'm gonna say this, you mentioned the board, you mentioned finance, it's more finance. Okay, boards come and go. Finance is the common thread. They've been doing this since the first day, making sure that we had the money available to take care of business. Okay, so thank you, Finance Department. All right, may I now have a motion to complete the business portion of this meeting? May I please have a second? All those board members in favor of ending the business portion of this meeting, please state aye. Opposed, state nay. The ayes have it. The business portion of the meeting is now closed. We will now do the normal